This case is apparently complex, but it's a case we can use to revise all the things we've said. Tizio is a French citizen. Tizio is a French citizen, and Tizia is an Austrian citizen. They married in Austria in 2014, so before the date of the applicability of the regulation, and they decided the first habitual residence is France. On the 31st of December 2016, the man, Tizio, bought a house in Italy. So we should see what is the regime under which he bought the house. Then, in January 2021, the spouses, together with the children, transferred their common habitual residence in Italy, where they all have residence. So, in 2021, they moved their residence to Italy. Now they would like to buy a house in Italy where they can live. They would like to have the facility of tax relief for the purchase of the first house. And this house is in the same municipality of the house they bought in 2016. They do not have specific needs for the registration of the first house to purchase, and not in connection with the law. They should be regulating the property regime. So he's French, she's Austrian. They get married in 2014. What shall we use to choose the applicable law? Private international law system, because the marriage is before January 2019. Private international law says that where the marriage life resides, the first habitual residence is France, and we can think then only 2021 they moved to Italy. Then they had residence in France, so we should apply the French law. So the French law, is it, are we certain about this? We should see what Renvoi says. What does the French law say? And this is what I write here. Until the enactment of law, the applicable law for property regime was the residence. After marriage, the French law does not ask for a renvoi. So these spouses until the 1st of January 2021 have a property regime regulated by French law. As we said, it is the community of property. Second question, who does the house belong to? The house bought in 2016. It falls within the community of property because we have the legal community of property. This house belongs to both spouses. In January 2021, the family moved to Italy where they have their residence. There is a change of localization of the marriage life. The applicable law, therefore, changes too, because according to the old private international law, the change of residence of marriage life for couples or spouses with different nationalities follows. From the 1st of January 2021, these spouses will be automatically subject or liable to the Italian law with the community of property, but this does not have an impact on the house, both in 2016, because that is a crystallized case. It's in the community of property, even though the law would speak about the separation, the division of property, it wouldn't change. But at this point, spouses have already a house together in the same municipality where they want to buy another house. So they go to the notary and they would like to have a facility, a special tax relief for the purchase of the second house. We should also take into consideration and know that in France, the legal regime is the community of property, and in Austria, you do not have this. What is the solution? Can we have them choose the applicable law? We can have the choice of the Austrian law with the separation of property with a retroactive effect. And the house bought in 2016 will only be the property of the husband, because with the Austrian regime, it is as if it were bought with the separation of property. And then in that case, the wife doesn't have a house and she can buy the second house with the tax relief facilities. This case is related to a practical case Giovanni had to deal with. He's going to speak about this. I have another similar case where the peculiar thing in this second case is what follows. I don't know if you remember, we've always said that for common law countries, the United Kingdom, Sri Lanka, the United States, lex recite is applicable. I mean, if you want to apply the common law, there is a renvoi to the law of the state where the property is. I will ask my client to make a choice of law in compliance with the Anglo-Saxon, with the common law, because the choice of law is in compliance with the regulation. In any case, if it is in compliance with regulation or the old private international law, when there is a choice of law, the renvoi is ruled out. With the choice of the common law, I do not have the issue of lex recite. I will have a choice where the spouses will be in the separation of property, and then the other spouse can buy the second house. Giovanni has the floor.